Good afternoon, everyone. This is Dr. Claire Bratton, and today I'll be discussing Chapter 5, Crimes Against Persons, specifically the crime of criminal homicide. For this chapter, we need to know the following concepts. We need to know the definition of person, who determines whether or not a certain creature is a person, and when that person is alive, in order to be able to define the crimes of murder and manslaughter. Because remember, only persons or human beings can be victims of murder or manslaughter. So don't forget, first, for this chapter, you have to assume that criminal homicide is different from all other crimes because of the finality of its results. With criminal homicide, what is the end? What's the ultimate outcome? Death of the victim. Okay. So criminal homicides are all about grading the seriousness of the offense. That's why in under Texas law we have felonies in the first degree, felonies in the second degree, and then you have manslaughter, and also you have finally at the lowest level in terms of seriousness would be criminally negligent homicide. Another thing that we should remember is that criminal homicide laws apply to corporations, but they are rarely prosecuted. Fourth, voluntary manslaughter is an intentional killing triggered by enough provocation or adequate provocation. And fifth, provocation is not an excuse for criminal homicide, so it's not a defense. Just because you were provoked as an offender, it doesn't mean that you are justified in killing another person. We'll go into detail as to what adequate provocation is later in this particular lecture. So what was the history of murder law? Under common law, judges divided homicide into criminal and non-criminal. In the 1550s, criminal and non-criminal homicide were further divided into criminal murder and criminal manslaughter, and non-criminal murder, which included justifiable and excusable murders. Okay. In context, we should look at statistics of murder. In 2004, there were 16,000 murders and attempted murders reported to the FBI. 1.367 million violent felonies and attempted violent felonies were reported within the same year. So this comparison would show you that criminal homicides are rare, but it is still a serious crime, okay? And in Texas, there were about 1,400 murders and non-negligent manslaughters each year. In contrast, driving and drinking deaths would average about 1,600 per year, and other traffic accidents would be average about 2,000 per year. So you can really see that other crimes occur more often than murders and non-negligent manslaughters. Under common law, there were two types of homicides. Okay, first, murder, which is the killing of a person with malice aforethought, and manslaughter, which refers to killing a person without malice aforethought. So you would ask me, what does malice aforethought mean? Malice aforethought means hatred, ill will, spite, and disrespect toward another. In Gonzalez versus Tate, malice was described as a condition of mind which shows a heart that disregards social duty and is fatally bent on mischief. Aforethought, on the other hand, means premeditation. So under common law, murder requires that you premeditated your acts and you were driven to commit that particular offense because of hatred, ill will, and spite toward the victim. Let's look at this example. Jack is committing a robbery of a fast food restaurant. Ronald, the cashier, attempts to phone the police. Jack fires a pistol directly at Ronald and kills him. Was Jack's decision one of malice aforethought? Did Jack act in a premeditated manner? Or was his decision to kill Ronald made on the spur of the moment? So you have to consider here whether or not he intended to kill Ronald, okay? Was his act in firing the pistol directly at Ronald, was it intentional? Did he intend to kill Ronald, okay? you would think that in this case, Jack would know, okay, that if he fired the pistol directly at Ronald, and if the pistol is discharged and the bullet hit Ronald, especially at close range, then it would definitely result in Ronald's death. So, what are the degrees of murder? Under common law, murder was divided into degrees. You have first degree, which covers intent to kill murder and felony murder, and second degree, which covers all other purposeful killings. What is the rationale for dividing murder into different degrees? First, not all murderers should be executed for their offense. Second, the law imposed different punishment for different degrees. For example, for first degree murder, the maximum punishment would be 99 years imprisonment to life without parole or death. On the other hand, the maximum punishment for second degree murder is 30 years. Okay, so under common law, there are two types of first degree murder: premeditated, which has deliberate intent to kill, and felony murders. The first degree murder under common law is the only crime type for which the death penalty is imposed. So how would this be imposed? This would be imposed in the second phase of a bifurcated trial. The first phase would be the trial proper to determine guilt or innocence of the accused. And the second phase for trial would be a proceeding to consider the type of sentence and the extent of sentence penalty to be imposed on the offender. Here in the second phase, the jury or the judge can consider aggravating factors that would increase the seriousness of the penalty and mitigating factors that would lessen the period of the penalty against the offender. So what about second degree murder then? Well, this was created to limit capital punishment without eliminating it. For example, second degree murder refers to unintentional murders. About felony murders? Felony murders refer to unintentional deaths during the commission of certain felonies. What are these felonies covered? Criminal sexual conduct, kidnapping, robbery, arson, and burglary. So any unintentional death or death that was not foreseen, not intended by the offender who is committing any of these 5 felonies would be considered felony murder under common law. So now, what is manslaughter then? Well, manslaughter is the unlawful killing of another, which may be either voluntary, upon a sudden heat, or involuntary, where one had no intent to do another any personal mischief. This is the definition of Blackstone. It refers to purposeful killing under the influence of a sudden rage of passion arising from adequate provocation. So, in a trial for murder, for example, you can show that as the offender, you were provoked by the victim and that provocation was adequate, meaning that it would have caused anyone in the same position to experience a sudden rage of emotion such as anger, hatred, that provoked the offender into killing the victim. So this would be adequate provocation. It is killing that is triggered by adequate provocation arising sudden that leads the offender to have this surge of emotion such as anger or hatred. So, what is voluntary manslaughter? Voluntary manslaughter under common law can occur under 2 circumstances. The first one, which I previously explained, which is when the offender kills someone because he experiences a sudden heat of passion because of the adequate provocation of the victim. Remember here that the victim must have provoked him adequately. If the provocation is inadequate, then it would not be just voluntary manslaughter, it would be murder. I'll give you an example. If the victim provoked, according to the offender, the victim provoked the offender by saying, "Hey, loser," okay, and the offender suddenly beat the victim to death, this will not be considered adequate provocation. Why? Because calling someone loser is not adequate to provoke someone or any person, ordinary or average person, to be angry, right? Being called loser does not, for example, it doesn't let me feel that I am justified, or it doesn't make me feel angry enough to kill someone. So it has to be adequate provocation. It has to be a slur. It can be a racial slur. It can be something that would incite an average person to be angry, to experience emotions or hatred to such extent that the offender would kill the victim. It's not justified. It's still voluntary manslaughter, but it's not murder. Okay. The second situation of voluntary manslaughter is the honest belief that killing was necessary in self-defense. So remember that under the Texas Penal Code and under most statutory codes, there is such a thing as there is such a thing as self-defense, okay, or defense, various defenses that will allow you to escape criminal liability. Now, if the elements of self-defense is not complete, not all the elements are present in a case, such as an imperfect self-defense, you would not you would still be liable, but the liability would not be murder. Instead, it would be voluntary manslaughter. Another situation for imperfect self-defense would be an overreaction on the offender's part or unreasonable behavior on his part that leads him to kill the victim. Okay. Let's look at this example of imperfect self-defense. Bart attacks Terry to rob him. Terry, a professional wrestler, subdues Bart, but instead of waiting until the police arrive, beats Bart to death. Bart dies. Now, assuming that Terry's response was unreasonable and excessive, he may be held liable for voluntary manslaughter. Let's look at this involuntary manslaughter. Involuntary manslaughter is the unintended death resulting from an unlawful act or criminally negligent behavior. The central elements include the actus reus, which is the actual criminal conduct, the mens rea, which is the criminal intent, okay, criminal mind, causation, meaning that the actus rea and mens rea concurring together, existing together, caused the outcome, and then the outcome, which is the resulting harm, must lead to death. There are two types of involuntary manslaughter. First, you have criminal negligence manslaughter and unlawful act manslaughter. An example would be drinking and driving. Now, what are some issues in criminal law? One issue in criminal law is motive. In any crime show or crime movies, television series, we see that prosecutors or police officers usually try to determine motive, okay? So why do they try to do this? There are several things. First, if you identify motive, then you can identify suspects. Let's look at this example. Alan is found dead in his apartment. Police officers arrive at the scene and investigate circumstances surrounding his death. To identify possible suspects, they have to determine who had reason to kill Alan, which is a motive. A second purpose of proving motive is that you show that the killing was intentional and not accidental. This is particularly true if there is no evidence, such as eyewitness or object evidence. For example, Barry admits to killing Alan, but claims that shooting was accidental. However, the day before his death, Alan fired Barry as an executive at Alan's company. So this would establish motive, right? Or let's say Alan was having a sexual affair with Barry's girlfriend. Again, this would establish motive and proof that Barry intentionally killed Alan. The third purpose is that it satisfies human curiosity. This is particularly important in order to win the jury over if you're the prosecutor. Now, another issue in criminal law is the meaning of person or human being, okay? Because only human beings or persons can be victims of criminal homicide. Now, recall under previous chapters the corpus delicti rule under Texas law, which states that when you're prosecuting for murder, discovery of a dead body is required, okay? When you are presenting a confession as evidence. However, corpus delicti is not required when confession is not offered in evidence. Now, the definition of person in homicide presents a problem at both ends of the cycle. When life begins tells us when a potential victim becomes a victim, and when life ends tells us when a real victim is no longer a victim. This is particularly true when we're talking about unborn children, unborn fetus, for example. Are they considered human beings for purposes of criminal homicide? Okay. Under common law, the fetus must be born alive for the offender to be charged and convicted of murder. Case law, however, states that the fetus must be viable, capable of existence independent of the mother. So you have the born alive rule. Under Roe versus Wade, the constitutionality of the Texas criminal abortion statute was considered, and the Supreme Court divided the pregnancy in trimesters. In the first trimester, the first 13 months of pregnancy, the woman had, or the mother had, the absolute right to privacy, and the Supreme Court said that the state cannot ban abortion. During the second trimester, this from the 14 to the 26 weeks, okay, the state may only regulate the abortion procedure in ways that are reasonably related to the maternal health. For example, if during the pregnancy it's discovered that carrying it to term would be a danger to the mother's life or health, then there could be abortion. There could be abortion restrictions. During the third trimester, when the fetus is fully viable, meaning that the fetus can exist independently of the womb of the mother, under Roe v. Wade, the state can choose to restrict or prescribe abortion as it sees fit. Okay. And the exception is where it is necessary in appropriate medical judgment to preserve the health or life of the mother. So what is a human being under Texas law? Disregarding everything that I said in the previous slide, under Texas law, section 1.0726, an individual is a human being who is alive, including an unborn child, at every stage of this gestation from fertilization until birth. So you can see that from the moment of conception, an unborn child is considered a human being for purposes of murder. And if you're an offender and you you murder a woman, a pregnant woman, you would be liable for multiple murders, capital murder, because you killed more than one person at the same time. The unborn child who's in the mother's womb would be considered a human being under Texas law. Section 19.06, however, excludes death caused by lawful medical procedures from the scope of coverage of the criminal homicide. In Lawrence versus State, capital murder was imposed for killing a pregnant woman who was 4 to 6 weeks pregnant at that time. What are the exceptions to criminal homicide? Section 1906.06 of the Texas Penal Code provides that the mother of the unborn child is not liable for any actions that results in the death of the unborn child. Okay. Second, lawful medical procedure. For example, if it's performed by a physician or other licensed healthcare provider with the requisite consent, if the death of the unborn child was in the intended result of the procedure or as part of an assisted reproduction. So the physician or health care provider is also not liable for criminal homicide. Third, dispensation of a drug in accordance with law or administration of a drug prescribed in accordance with law. So when is a person dead? First, you have to consider clinical death. So here, if the person's heartbeat stops, it's considered clinical death. Biological death, on the other hand, refers to the cessation of brain functions. Okay. Under Texas law, a person is considered dead if there is an irreversible cessation of a person's spontaneous and circulatory functions. So he stops breathing or his blood stops circulating, or If a person is on artificial life support, it is the announced opinion of the physician that there is irreversible cessation of all spontaneous brain functions, and the opinion of the physician must be based on ordinary standards of medical practice. Okay, having said that, now let's look at Section 19.01, the Texas Criminal Homicide. Under the Texas Criminal Code, there are five different kinds of homicide. First, you have murder, which refers to intentional or knowing murder. Homicide. You have capital murder, also requires intentional or knowing mens rea. You have manslaughter, which refers to a mens rea of recklessness. Intoxication manslaughter, it requires a mens rea of recklessness. And criminally negligent homicide, which requires criminal negligence. Now, the first type of murder is intent to kill murder. Okay. So what is intent to kill murder? You have to intend to cause the death of another. For example, if you stab someone multiple times at major arteries, you have the intent to kill because you know that the purpose of that stabbing is to cause the death of another person. Second, knowingly causing the death of another person. If you acted or engaged in conduct knowing that death is reasonably certain to occur, for example, you shot someone and the bullet ricochets, you know that simply the act of shooting and discharging that weapon, if the bullet hits someone in the vicinity, that person would die. Okay? Under Texas law, intent to kill murder does not require proof of the element of malice aforethought, premeditation, or motive. So you don't need to present those elements or provide proof of those elements. The second type of murder under Texas Penal Code is intent to cause serious bodily injury murder. Recall that serious bodily injury refers to permanent disfigurement or protracted loss of body members. So, if you intend to cause those serious bodily injury and death results, okay, then you would be liable for serious bodily injury murder. You cannot say that, hey, I only intended to cause serious bodily injury. I did not have the intent to kill the victim. Okay, as long as you're engaged in doing those acts, okay, causing serious bodily injury to someone, and those acts are clearly dangerous to human life, okay, and those acts were in furtherance of the felony, you would be liable for the death of that person. The third type of murder would be felony murder. Okay. There is a difference between felony murder and capital murder. When we're talking about both felony murder and capital murder, in certain situations, an intended death, so if you intend the death of the victim, the intended death of the victim, when you're committing certain types of felony, would result in you being charged with capital murder. However, if the death was unintentional, okay, but in furtherance of the felony or while immediate flight from the crime, you would be liable for a felony murder if you were committing an act that is clearly dangerous to human life. Okay? So, example, let's look at this example. Setting fire to a building to cover burglary. The act of setting fire to a building is clearly dangerous to human life. So you would be liable for felony murder. How about passing a forged check at a banknote using a note, okay, because you want to get money? If the teller dies of heart attack, this is unintended death. You would be liable. Would you be liable for felony murder? Probably not, because the book says that passing a forged check at the bank is not clearly dangerous to human life. Okay, so what's the penalty for murder? Murder is a felony in the first degree. Again, let's review. There are three types of murder: intent to kill murder, intent to cause serious bodily injury, and felony murder. The punishment for murder is 5 to 99 years maximum in prison, okay, plus $10,000 fine. However, look at this. During the punishment phase of a bifurcated trial, you, the offender, can plead that the first degree murder be reduced to a felony in the second degree or manslaughter if you prove that you acted under the immediate influence of sudden passion arising from adequate cause, in which case, instead of a possible maximum 99 years, you would have a maximum of 20 years imprisonment. Now, how do you do this? So, as I mentioned, you have to prove that you were provoked, okay? You experienced a sudden passion because the victim provoked you. And that passion, that hatred, that anger, that intense emotion arose at the time of the offense, okay, at the time of the death. So, what would be an adequate cause? So, you have to say that the victim uh, provoked you, okay, and the provocation was an adequate cause, meaning that anyone else, okay, anyone else who had an average temper or ordinary temper would experience the same degree of anger, rage, resentment, or terror when faced with the same provocation. Now let's go to capital murder. Please note that under the Texas Penal Code, only intent to kill murder can be transformed to capital murder. So intent to kill to cause serious bodily injury murder and felony murder cannot be transformed to capital murder. Only intent to kill murder. Now, there are 5 situations wherein murder is transformed into capital murder. First, if the victim is a police officer or fireman on official duty, and the offender knows that the victim is a police officer or fireman. Second, intentionally committing murder during a dangerous felony. However, the Texas Penal Code only limits the felony offenses to seven offenses. And I created this mnemonic for you to remember. Abel killed Bart to own a Range Rover. So Abel refers to aggravated sexual assault. Killed refers to kidnapping. Bart refers to burglary. To refers to terroristic threat. Own refers to obstruction. A refers to arson. Range refers to robbery. And Rover refers to retaliation. So only intentional murder during the commission of aggravated sexual assault, kidnapping, burglary, terroristic threat, obstruction, arson, robbery, and retaliation would elevate the crime to capital murder. So, third, murders for remuneration. So if you receive payment, okay, for killing the victim, okay, it would be considered capital murder. Murder while escaping from a penal institution, or if you murder a person, a prison employee, or a gang member. Now let's look at this case. Bruno, a country inmate, is secretly crawling under the fence of the jail where he is confined. A pedestrian walks by, sees Bruno, and attempts to alert the guards. Bruno kills the pedestrian to stop his outcry. Did Bruno commit capital murder? Yes, because he is an inmate escaping from a penal institution and he intended to kill the pedestrian. How about this? Bobby, an inmate, successfully escapes from prison. 2 weeks later, Bobby murders Roger to seek revenge for Roger's theft of his bicycle 2 years earlier. Did Bruno commit capital murder? No, because Bobby killed Roger in a separate instance. It wasn't while he was escaping from a penal institution. The sixth situation of capital murder is if an inmate murders another inmate. However, there has to be qualifications of the inmate offender. In order to be liable for capital murder, the offender inmate must be serving time for capital murder or is serving time or life sentence or 99 years for aggravated kidnapping, aggravated sexual assault, or aggravated robbery. To illustrate the second instance of capital murder where an inmate kills another inmate, let's look at this case. John is serving 30 years in prison for aggravated sexual assault. He kills his cellmate Bruno. Is this a capital offense? No, because John is serving 30 years, he is not serving 99 years for aggravated sexual assault, in which case he does not fall under the sixth provision of for capital murder. Number 7, the offender commits mass or serial murder. So what is mass or serial murder? It has to arise, the killing or the death has to arise from the same criminal transaction, meaning that there has to be a continuous and uninterrupted chain of conduct occurring over a very short period of time. Okay, so what happens if there are different transactions but same scheme, motive? It's still serial murder. For example, this guy, Zodiac Killer of California, over the course of 4 years, he murdered 3 persons, sending poems to the media claiming credit for the crimes. This would be capital murder. 8, the offender murders a child under 10 years old. 9, the offender murders a judge. And look at the qualifications. The killing must be related to the judge's performance of official duties, or the killing must be in the course of committing a retaliation or obstruction. For capital murder, the penalty is death or life without parole. So how is the death penalty imposed? The jury would have to answer 3 questions. Number 1, is there a probability that the defendant will be a continuing threat? 2, is the defendant an accomplice or did he anticipate the victim's death? 3, do mitigating factors exist that warrant life without parole instead of death? To impose the death penalty, the jury must answer yes unanimously to questions 1 or 2. And again, to impose the death penalty, the no answer to either 1 or 2 needs 10 votes. Okay. What is manslaughter? It is reckless behavior punished as a felony of the second degree. Examples would be traffic-related deaths, where the defendant drives 87 miles per hour in a 45 mile per hour zone on a 2-lane hilly roadside. Another example would be careless handling of firearms. Let's look at this case. Mary points a loaded gun at Ralph and pulls the trigger, killing Ralph. Mary claims that she did not know anything about guns and had forgotten that the gun was loaded. This would be manslaughter because it's reckless, okay? Reckless behavior. So let's define recklessness. Reckless mens rea is one element of manslaughter. So under Texas law, the risk must be substantial and unjustified. For you to be considered reckless, you must be aware of but consciously disregard a substantial and unjustifiable risk. And there has to be gross deviation from a standard of care that an ordinary person would exercise under the same circumstances. Okay, so the rule here is, were you aware? Okay, were you aware of the risk? Did you consciously disregard it? Okay, and was your disregarding of it a gross deviation from the standard of care that an ordinary person would exercise? That is how you determine recklessness. Intoxication manslaughter. An example would be if the offender is operating a motor vehicle or watercraft, assembles or operates a mobile amusement ride. While intoxicated, he kills another. What is intoxication? Under Texas Penal Code, intoxication refers to a blood alcohol level of 0.08, or even if it's not 0.08, depending on your body type, it refers to loss of normal physical and mental facilities due to ingestion of any substance. For you to be liable for manslaughter, intoxication manslaughter, you must prove, the court or the jury must prove a causal connection between the death and the intoxication. Let's look at this case. One rainy night, Dan is driving his pickup truck while drunk. Paul, who is wearing dark clothing, attempts to cross the roadway. Because of poor visibility due to the weather, Dan does not see Paul and hits and kills Paul. Here it is doubtful that there is a causal relationship between Dan's being drunk and the death of Paul, because of an intervening cause, bad weather. About this, Dan, with a blood alcohol level of 0.21, drives at 100 miles per hour and strikes a stalled vehicle by the side of the highway. Paul dies from the collision. Here, there's definitely a causal relationship between Dan's being drunk and Paul's dying. So he would be liable, Dan would be liable for intoxication manslaughter. Let's look at this case. Dan, with a blood alcohol level of 0.05, while operating a motorboat, hits and kills Paul, who is scuba diving. So here, even if his blood alcohol level does not meet the criteria under the Texas Penal Code for him to be considered drunk, alternatively, the prosecution can show that he lost his normal physical and mental facilities due to intoxication, if they want to make Dan liable for intoxication manslaughter. Now, what is criminal negligence? It's a state jail felony. Here, the focus of the prosecution would be what the defendant ought to have done under the circumstances. And it applies to violation of traffic laws, health and safety regulations, and other statutes. So when are you criminally negligent? And so that when it causes death, okay, you're liable for criminally negligent homicide. So the standard for criminal negligence is that you ought to have been aware of a substantial and unjustifiable risk, and you substantially deviated from the ordinary standard of care that an ordinary person would have exercised under the same circumstances. This next case illustrates criminal negligence. Dina is putting on makeup while driving, and she accidentally hits and kills a pedestrian. Is she liable? Yes, because Dina ought to be aware of a substantial and unjustifiable risk of her putting on makeup while driving. Since she was not focused on the road, but focused on putting on makeup, she ought to have known that it's possible that she would get into a traffic accident, including killing a pedestrian. Did she substantially deviate from an ordinary standard of care that an ordinary person would exercise under the same circumstances? Yes, because ordinarily, a woman who is driving, a female who is driving, if that female would exercise ordinary care, that woman or that female would not put on makeup. Okay, so Dina is negligent. Now, the next couple of slides will illustrate the different degrees of murder, manslaughter, and criminally negligent homicide, as well as the mens rea required for this. Now, Martinez versus State was a case decided by the Fourth Court of Appeals of Texas. It happened in December 13, 2011, here in San Antonio. Rodriguez and 3 passengers were driving on I-10, US 90, and they had been smoking marijuana, so that Rodriguez was driving slowly. As they were exiting toward Interstate 37, Bonifacio, driving a black BMW, came up behind Rodriguez's car on the exit ramp. The BMW was flashing its lights, okay, because apparently it wanted to overtake Rodriguez, but Rodriguez pumped on his brakes to warn the BMW that it was following too closely. After they exited toward I-37, the BMW passed Rodriguez's car on the right, and the driver glanced at them. Meanwhile, Martinez, the offender, who was driving a white 4-door Buick car, drove up on the left side of Rodriguez's car. Martinez passed them. Both this white car and the BMW went in front of Rodriguez's car and brake checked Rodriguez, and the drivers, who were brothers, engaged in a conversation. After that, the driver of the white car slowed down, lined up next to Rodriguez's car, and Rodriguez and Martinez exchanged words, okay? And shots were fired from the white car, and Rodriguez was hit by the bullet. Now, the BMW and the white car drove off. One of the passengers in Rodriguez's car was able to grab hold of the wheel and pull it over. Another passenger called 911. The BMW and white car appeared to be waiting, but they exited as soon as they saw the ambulance. Meanwhile, Rodriguez died from the gunshot wound. Now, Martinez, the driver of the white car, was convicted of murder. He appealed with the Fourth Court of Appeals of Texas, claiming that he was entitled to the lesser included offense of manslaughter because he only shot at the car and did not point the car directly at anyone inside the car. Okay, so he was saying that he merely acted recklessly, okay, which would reduce it to instead of murder, which requires intent or knowing mens rea. He wanted to be liable only for manslaughter. The court said that there is no evidence showing that he was merely reckless. First, he had told several people that he was angry with the driver of the car for cutting off his brother and that he would do anything for his brother. Also, he intentionally positioned the white car, the Buick, along the left side of Rodriguez's car and fired 2 shots in the direction of the driver's seat, knowing that Rodriguez was just sitting in the driver's seat on the other side of the door and the bullet could possibly hit him. So the jury could have inferred that Martinez intended to cause serious bodily injury to one or more of the occupants in the car when he fired the gun directly twice at the driver's side. So he is liable for murder and not merely manslaughter. Now, let's look at this next case, Mallard versus State. In October 25, 2001, 2 female friends, Mallard and Fry, had a few drinks, one ecstasy and marijuana, while having fun at Joe's Big Bamboo Club. Mallard was then too drunk to drive, so Fry drove them home back to Fry's home. But however, Mallard wanted to go home, so she drove her car from there. Now, while driving on the freeway, she hit a guy who got stuck in the right front windshield of her car. She parked the car at her garage, with the guy still stuck on the windshield. She heard him moan while parking. She then called her friend Fry, who came over and saw the guy. Fry told Mallard to call 911, but Mallard did not. Autopsy revealed that the victim, Biggs, suffered a near total amputation of the left leg and bled to death from the injury. Mallard was convicted for felony murder. So what is the underlying felony? The felony was failure to stop and render aid. The court said that her clearly dangerous act in furtherance of the felony was transporting Biggs to her home seriously injured, lodged in her windshield, hiding her in her garage so that it prevented him from seeking medical help. The appellate court held that Mallard's actions related to the felony of failure to stop and render aid were clearly dangerous. She failed to stop and call for help at the 9 payphones between the accident site and her home and failed to drive to the nearest fire station to obtain medical assistance. That's it. Thank you so much for listening to my lecture. I hope you learned a lot. I'll see you next time.